In this video, I want to give sort of an overview, big picture overview of the legal claims process following a car crash. So initially what's going to happen is someone goes to the doctor, maybe they go to the hospital, get treatment, physical therapy, chiropractor, things like that. What's going to happen, especially if you hire an attorney, is we will be gathering that information, getting medical records, getting bills from the hospitals, getting reports sometimes from doctors, but getting information to help support the claim for injuries and damages, gathering earnings information from you or your employer, um, doing things like, compiling photographs from the crash, inspecting the vehicle, maybe having someone go out and look at the vehicle and take some measurements if there's a dispute, if we expect there's a dispute over who caused the crash, speeds, which lane people were in, things like that. So gathering that kinds of information as someone is healing, and once someone reaches either the point of maximum healing or maybe we're getting close to a statute of limitations or something like that, we're putting together a demand package. Before all that, however, usually a claim is going to be submitted to the insurance company for the other driver. It's something we want to do as soon as possible. Notify them of the claim, request policy insurance, information, things like that. They sometimes will give that information, sometimes they won't. But gathering that information, finding out what the insurance situation is for the other driver, something kind of going on early on. Once that's all put together, and if we have the information to submit a demand package, usually it's a long written letter detailing the relevant facts of the case, maybe the law, medical support, things like that, submitting a formal demand on the insurance company, typically for the other driver. If they didn't have insurance, maybe it's on your own insurance policy as a demand for uninsured or underinsured motorist benefits, but it's a written demand on the insurance company with a deadline to respond, usually 30 to 45 days, something like that. When negotiations are happening, especially if a deal has tentatively been reached even before a lawsuit, there are some other things going on. For example, your attorneys will be negotiating with any subrogated or lien holders. I've talked about those in other videos, such as health insurance, Medicare, Medicaid, maybe workers' compensation, MedPay under your own auto policy, things like that. Negotiating with them because they will have a subrogation interest, but they may not be entitled to the full amount, especially if it's a settlement for less than the full value, because let's say there's not adequate insurance limits, things like that. Those are all things that are going to be going on. If someone is going to require future care, it may require setting aside some money for that future care that arises out of whatever car crash or whatever that we're talking about here. Some union-based ERISA health plans will require that. Medicare, if someone is on Medicare or may eventually become eligible for Medicare, Medicare may require you and your attorneys to take that into account, possibly set aside some money for payment for coverage of those out of the settlement funds. So that's kind of all going on. If there's either a potential settlement or a settlement agreement reached, so that those parties can be paid, they can sign releases, and the whole matter can be resolved. Sometimes there isn't time to do a demand letter, or the demand doesn't result in a settlement. Then the next step is usually a lawsuit. A lawsuit simply means filing formal papers. Usually it's called a summons and complaint or a notice and petition, something like that, which actually officially starts the lawsuit and serves the other parties, sometimes their insurance company as well, with papers about the lawsuit that actually starts the process. And then from there, the parties go through a formal process of exchanging information and documents, taking witness testimony through depositions, hiring experts, getting ready for trial, things like that. During that time, it is normal for negotiations to continue. And a lot of cases that don't settle before a lawsuit started still settle afterwards during a lawsuit, maybe because the parties have more information at that point in time. So, something to keep in mind is, while if at all possible, we try to settle cases without filing a lawsuit, it's not the end of the world if a lawsuit is filed, and sometimes a lawsuit is necessary to get the attention of the insurance company and make them pay fair value for the loss, that was sustained. So that's sort of the normal process. Um, Simple claims can take weeks to months to resolve. More complex cases can take years. Sometimes, because of the length of time, like I mentioned above, it becomes necessary to file a lawsuit because the statute of limitations is coming up and we're still not at a point. Maybe the person is still treating, maybe we're still gathering information. So sometimes a lawsuit has to be filed because of the statute of limitations to preserve those rights.